All right, court's on the record, Commerce City Municipal Court for the afternoon session of March 18, 2021. For the people that are on Zoom, please mute your devices. When I call your case, I'll ask you to unmute your device. If this is your first appearance on this case, then you must first watch the advisement of rights video before I call your case. Take the opportunity right now to do that while I deal with some other cases if you have not already watched the video. You can find the video at commercecitycourts.com, and there's a link there that'll take you to the advisement video. Well, there's only one person in the courtroom right now. Mr. Barnett, if you would come forward to station number 1 there. Good afternoon. I'm doing all right. I need to pull up what I can on what I have in your case. Give me just a second. All right, so it's EM. Yeah, I think you're right. His ticket is for failure to stop at a stop sign, and or a stoplight. So that's what you're dismissing. You can't be dismissing this, and this is a different case number, obviously. Right? Yeah. Okay. And you are not, Mr. Barnett. Yeah. All right. So I'll do that on this document. I'll set aside the default that entered when you failed to appear on March 3rd. I'll go ahead and set aside the default. And then I don't know how I can do this. Give me a second. Okay, question for you two. On this case, when I entered the default back on March 3rd, I have the face sheet in the system, and I'm setting aside the default today and dismissing this case. I can't just edit this. I need to load a second face sheet, don't I?
No, I think you should be able to edit that one.
Well, no, because it's a default. So, okay, so I'm going to load a second face sheet just to be safe. All right, so let me do this. And Mr. Barnett, so that you don't have to wait for me, I'm going to enter the order dismissing your case. I'm going to send you to the windows in the lobby to see my clerk. They'll give you a copy of the order of dismissal of your case, and then you are free to leave. Then I'm going to load a new face sheet explaining that I've set aside the default and dismissed this case. Okay? All right. Uh-huh. I'm sorry, say that again? Sure. Well, it doesn't really matter. I'm dismissing it. All right. All right. If you'll go ahead and stop at the windows in the lobby and see my clerk. Uh-huh. Okay, so now I'm going to Oh, great, now it's changed. I used to hit process and then it used to say index to case, and now it's saying select courtroom or chambers and then arraignment. I think it's this. I don't know. I've never had this happen before. Okay, yeah, it does. It does. All right, so yeah. So now it's indexed to case. And so now I can go back to the case, go back to docket management. This is the face sheet from today. All these people on Zoom are getting a play-by-play blow of how I'm administering this traffic case.
And then I have one more for you in the breakout, and then you're done on Zoom for the time being.
I saw him here, Mr. Zarlingo.
So, where's that Christopher dude? Where's that stuff? Oh. So Christopher got information from another attorney saying that he's now his attorney.
Is he on Zoom?
Yeah, but there should be something in there from the new attorney, because Christopher said he's not gonna. And they haven't saw that file at all until now?
Is Weston Novak on Zoom?
Your Honor,
Yes, sir.
he is.
Okay. And Mr. Sawyer, are you entering on behalf of Mr. Novak?
Yes, Your Honor, I am.
Did you send an email or anything to my staff?
We did. We've had communication with your staff regarding our entry and
Okay,
whether
give
or
me
not
just
we
a
need
second.
to.
For some reason, I don't have it yet.
Not a problem.
Give me just a second. I mean, it might be in here, I just don't see it. Maybe it's in Adam's file. Oh, so I don't need to keep looking for it because it's not in here? All right. All right, Mr. Sawyer, what's your registration number?
43810.
Say that again?
43810. Sorry.
That's okay. I heard the 3810, I just didn't hear the 4.
Yes, sir.
All right, so I'm going to allow you in. I'll allow Mr. Zarlingo to withdraw. And it's my understanding you simply want to set this matter over for another pretrial conference. Is that correct?
Yes, Your Honor. We were hired recently on this case, and so we just need time to get familiarized with it.
Okay. All right, take a look and see what your schedule looks like on April 15th or the 29th. We set these at 1:15 in the afternoon.
Your Honor, I can accept the 29th. I would take the 15th. However, my wife told me that on our vacation, I'm not allowed to set even WebEx appearances. So I've got to take the
I
29th.
certainly don't want to cause any discord. All right,
Thank you,
so
Your
we'll
Honor.
continue your case to April 29th. Thank you. Yep, here it is. All right, April 29th at 1:15 for pretrial conference. And just so that you know, this case is starting to age a little bit because of an earlier failure to appear on your client. I probably won't continue it for anything other than setting it for trial or a firm disposition beyond that date. We'll try to get it
Certainly.
wrapped up on that, okay?
Yes,
So
sir.
when you leave the meeting, my clerks are going to send you an email just with a confirmation notice of the new court date and time. Have you received discovery on this case yet?
Your Honor, I believe, and I apologize, I've been buried in motions that I've got due coming up. So I may have received discovery recently, but
Yeah, if
I'm
you
not
haven't, that's
100%
fine.
sure.
My clerks, when they email you, get back with them, and they'll arrange with the city prosecutor to get you the discovery. Okay?
Thank you, Your Honor.
Thank you. You and your client can go ahead and leave the meeting.
Thank you. Have a great day.
Uh-huh.
Thank you, Your Honor.
Yeah, this is something I should have had before so that I could fill all this out beforehand, but it's a light afternoon, so I got to take care of it. And Mr. Zarlingo, just so that you know, I've authorized you to withdraw on the, Mr. Weston Novak's case. All right, we have Victoria Orozco Solorzano. Please unmute your device.
Yes, Your Honor.
Okay, and is that your father with you?
Yes.
All right. Okay, give me just 1 second while I pull up the original ticket here. All right, I have a document that indicates that if Victoria pleads guilty to the added reduced charge of driving a vehicle with an obstructed windshield, this is a 0-point violation on February 2nd of 2021 at about 3:30 in the afternoon in the area of 16100 East 112th Avenue here in Commerce City. The city attorney will dismiss the original speeding charge against her. Victoria, is this how you wish to resolve your case today?
Yes, Your Honor.
Did you watch the advisement of rights video?
Yes, we did.
Okay. And as her father, sir, do you understand the original charge that was filed against your daughter?
Yes, Your Honor.
Do you understand the reduced charge that the city attorney is offering your daughter in an effort to resolve this case?
Correct. Yes.
Do you agree that your daughter is acting in her best interest by accepting this resolution and pleading guilty to this reduced charge?
Yes, Your Honor.
Thank you. Okay, Victoria, I'm going to go over some of the rights that you have that you viewed in the video. Do you understand that if I accept your guilty plea to this reduced charge, you're waiving your right to be represented by an attorney in this case?
Yes, Your Honor.
You're also waiving your right to be presumed innocent of the original speeding charge unless and until the city attorney is able to establish your guilt beyond a reasonable doubt at trial, because by pleading guilty to this reduced charge, you're waiving your right to have a trial. Do you understand that?
Yes, sir.
You're giving up your rights to confront and cross-examine any witnesses that the city attorney would call in support of the original charge against you. You're giving up your right to present evidence on your own behalf, including calling witnesses on your own behalf, and if your witnesses would not appear in court voluntarily, to have the court issue subpoenas for you free of charge, which could then be used by you to have your witnesses ordered to appear on the date of your trial. You're giving up your rights during the course of your trial to testify or to remain silent, and if it was your choice to remain silent, the fact that you did so could not and would not be used against you to establish your guilt. If at the end of the trial you were found guilty of the original charge, you would have the right to appeal that conviction to a higher court. Do you understand that if I accept your guilty plea to this reduced charge, you're giving up all of those trial and appeal-related rights?
Yes, Your Honor.
Has anyone forced you or coerced you to get you to plead guilty to this reduced charge against your will?
No, Your Honor.
Has anyone made any promise to you to get you to enter this guilty plea?
No.
Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today?
No, Your Honor.
Then to the added reduced charge of driving a vehicle with an obstructed windshield, a 0-point violation on February 2nd of 2021 here in Commerce City, how do you plead, guilty or not guilty?
Guilty.
I'll accept your guilty plea. Anything you want to tell me that I should take into consideration before I impose the sentence against you?
No, Your Honor.
Anything you want to tell me about your daughter that I should take into consideration?
No, Your Honor. Everything is correct.
Okay, well, you got to at least tell me that she's a good kid.
She is a great kid. She's the
Okay,
best.
there you go. All right, this looks like it's your first offense. How long have you been driving?
About 5 months.
Okay, Victoria, when you get behind the wheel of a car, you have one goal. Do you know what that goal is?
No. I do not, Your Honor.
No?
No.
Okay, that one goal is to get to where you're going safely, okay? I mean, a car is a very valuable tool, but it's also a dangerous tool. If you disregard what you're doing as a brand new driver and focus on other things, get distracted in any way, it becomes a very dangerous instrument. So from now on, when you get behind the wheel of a car, I want you to think about getting to where you're going safely, not more quickly. If you're late when you get into the car to make it someplace, just accept the fact that you're going to arrive late. Don't try to make up for lost time in your car. That's the number one mistake new drivers make. And I'm sure your dad would rather have you get home late, but all in one piece and safely, than have you speeding, 15 miles an hour over the speed limit or faster, just trying to make up for lost time. So as a new driver, you're already at a higher level of getting into or causing accidents than a more experienced driver. The last thing I want a young driver to do is to be speeding and allow themselves to be distracted as well. So just keep that in mind. In order to become a good driver, you get years and years of experience. The key behind the driving thought process has to be that you want to get to where you're going safely. If that means you have to slow down, you slow down. If it means that you don't take any chances, don't take those chances, okay? Do what you need to do to get to where you're going safely.
Okay.
All right, your scheduled fine in this case was $80, I think? Yep. I'm going to reduce your fine to $30 plus surcharges and court costs. When you leave the meeting, my clerks are going to get in contact with you either later today or sometime tomorrow. They're going to tell you what the total is of the fines and court costs. If you need them to, they'll work out a payment plan for you. They'll email you to whatever address you registered with, okay?
All right. Thank you very
Do you
much.
have any questions?
No, I do not.
Sir, do you have any questions?
No, sir. Thank you very much for your kindness.
All right, so would you can go ahead and leave the meeting, and my clerks will be reaching out to you by email. Have a good afternoon.
You too, sir. Thanks.
Okay, Alice Abril, if you would unmute your device. Good afternoon.
Good afternoon, Your Honor.
Okay, give me a second while I pull up your case. Okay, and are you his mother?
Yes,
All right, I have a document that indicates that if you plead guilty to the added reduced charge of speeding 55 in a 45-mile-per-hour zone, that's a 4-point violation, and attend the Alive at 25 class, the city attorney will dismiss the original speeding charge against you. Is this how you wish to resolve your case today?
Yes, Your Honor.
Okay. As his mother, do you understand the original charge that was filed against your son?
I do, Your Honor.
Okay, it was 82 in a 45-mile-per-hour zone. Do you understand the reduced charge that the city attorney is offering your son,
Yes, I do, Your Honor.
including the condition that he has to do a driving class? You understand that?
Yes,
Do you agree that your son is acting in his best interests by accepting this resolution and pleading guilty to this reduced charge?
I agree, Your Honor.
Thank you. Give me just a moment. And did you watch the advisement of rights video?
Yes, I did, Your Honor.
Okay, I'm going to go over some of those rights with you. All right, do you understand that if I accept your guilty plea to this reduced charge, you're waiving your right to be represented by an attorney in this case?
Yes, I do, Your Honor.
You're also waiving your right to be presumed innocent of the original charge unless and until the city attorney is able to establish your guilt beyond a reasonable doubt at trial, because by pleading guilty to this reduced charge, you're waiving your right to have a trial. Do you understand that?
Yes, I do.
You're giving up your rights to confront and cross-examine any witnesses that the city attorney would call in support of the original charge against you. You're giving up your right to present evidence on your own behalf, including calling witnesses on your own behalf, and if your witnesses would not appear in court voluntarily, to have the court issue subpoenas for you free of charge, which could then be used by you to have your witnesses ordered to appear on the date of your trial. You're giving up your rights during the course of a trial to testify or to remain silent, and if it was your choice to remain silent, the fact that you did so could not and would not be used against you to establish your guilt. If at the end of the trial you were found guilty of the original charge, you would have the right to appeal that conviction to a higher court. Do you understand that if I accept your guilty plea to this reduced charge, you're giving up all of those trial and appeal-related rights?
Yes, Your Honor.
Has anyone forced you or coerced you to get you to plead guilty to this reduced charge against your will?
No, Your Honor.
Has anyone made any promise to you to get you to enter this guilty plea?
No, sir.
And are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today?
No, Your Honor.
Then to the added reduced charge of speeding 55 in a 45-mile-per-hour zone, a 4-point violation on February 21st of 2021 at 11:50 in the evening in the area of Black Hawk and 104th Avenue here in Commerce City. How do you plead, guilty or not guilty?
I plead guilty, Your Honor.
I will accept your guilty plea. I'll find it's knowing, intelligently, and voluntarily made with a full understanding of the rights being waived as well as the possible consequences. Anything you want to tell me that I should take into consideration before I impose the sentence against you?
I would like to fight this case because I know I was not going 82 in a 45, Your Honor. But I would not like to put that burden on my mom and have her hire a lawyer or put that much time or effort into her because she has a job and I want her to succeed. So I would definitely plead guilty in this part.
So how fast do you believe you were going?
I just don't think I was going 82 or 55 because how he caught me, I was going the speed limit. But
Well, why would he pull you over if you were going the speed limit?
I don't know, because I swear, because I was going on 104th, there's 2 straight lanes and then median, and I was going straight and turning left. But he caught up to me pretty fast. And I know for a fact I wasn't going 82, because if I was going 82 on the opposite side of the median, he would not have caught up to me.
This is what he says. He says that he was obviously there doing speed patrol. He says that he noticed a vehicle approaching. He estimated the speed at approximately 80 miles per hour. He used his mounted radar, locked the vehicle 82 miles per hour. After contacting you, you said that you were driving fast because there was somebody that you thought was following you. The officer said that when he locked you in, which was earlier than when he pulled you over, he said there wasn't any cars immediately around you. So there wasn't anybody like tailgating you or following you too closely. So you have to keep in mind where he pulls you over isn't where he locked in the speed. Do you get that, right?
Understand.
Okay. All right. Is there anything you want to tell me about your son that I should take into consideration?
He's a good kid. He's
That's always a
trying.
good thing to say.
Yeah.
Did he have a curfew?
I know he was coming home from work. He works late until 11 o'clock or midnight. And we live in the eastbound area, and I know he was coming home during that time.
Yeah, no, I can see where he lives and I can see where the ticket was received, so that, that makes some sense. The thing that just gets me is the speed. Again, you
I
may have
agree,
just heard me
Your
talking to
Honor.
that young lady. The number one mistake new young drivers make is they try to make up for lost time in their car. They are in a hurry all the time, with all of the commitments that they have, work, school, friends, all that, and they think that in their car they're going to make up for lost time. It's a common mistake. So I always tell people, as a new driver, don't do that. Try to get to where you're going safely and make that your primary thought process when you're behind the wheel. All right, let me do the math here. All right, his schedule fine's $240. I'm going to impose the $240, but I'm going to suspend 140 of it, more than half, because I am going to order the Alive at 25 class.
Okay.
Okay, so when you leave the meeting, my clerks are going to tell you what the total is of the non-suspended portion of the fines and court costs, okay? They'll work out a payment plan for you if you need them to. You can spread it out over a few months. They're also going to give you the referral to the class. You'll have a deadline of about 6 weeks within which to complete the class. As soon as you get the referral, you'll either get that today or tomorrow. Contact the people, get the class set up, get it done, get us the certificate of completion by the deadline. It's your responsibility to make sure we receive that certificate on or before the deadline. Make 2 copies of it. I would say make sure that your mom gets 1 copy. You should send it into your insurance agent, because at his age, this ticket might cause your rates to go up, but they might give you a discount for him doing the driving class. The other copy you need to hold on to, just in case you ever have to go in front of DMV. It's good to have a copy of a certificate of completion of a driving class if you go to DMV. So original gets filed with the court, copy for your mom's insurance, copy for DMV just in case. Do either one of you have any questions?
No,
I
Your Honor.
don't.
Okay, then you're go ahead and free to leave the meeting. Thank you.
Thank you, Your Honor.
Mr. Zarlingo, I've got a couple of dismissals I'm going to take up before I call your cases up, okay? All right, Amber Dean, you can go ahead and unmute your device, please.
Yes, Your Honor.
All right, case number 297101. The city attorney is satisfied that you successfully completed the diversions and is filing a motion to dismiss. I'm going to grant that motion as soon as I find the original ticket in this mess of paperwork. There it is. Okay, on this case, you still owe a $50 warrant fee, I think, from when you failed to appear back in June of 2020. So I'm going to enter the order of dismissal, but I'm not going to close the case until you pay that $50. How much time do you think you're going to need?
Actually, I can pay it today. I tried to do it online. It just said I had to show up at court first.
Okay, we'll go ahead and make it so that you can go ahead and pay that, and once it's paid, this case will be closed.
Yes.
So give me just a second while I do that on this case. All right, in case number 294236, this is the shoplifting case from Walmart. Again, the city attorney is satisfied that you successfully completed everything, and I'm going to enter the order of dismissal in this case. This case, you could actually file a petition to seal the record of. There's a $65 filing fee that goes with it, but in this one, you have a failure to appear from December of 2019 and from June of 2020, so you owe $100 on this case. On this one, again, I'm going to enter the order of dismissal. I won't allow it to be sealed unless the $100 is paid on the warrant fees and the petition and the filing fee of $65 is paid on this one. When you get the email from my clerks about the dismissal on this one, you can ask them and they can send you information on how to petition the record to be sealed. Do you have any
Okay.
questions about that?
No, sir.
Okay, also work out a payment arrangement for the warrant fee, because it'll say that it's eligible, but can't be sealed unless the warrant fees are paid first, okay?
Yes, sir.
Okay, I think that handles both of the cases that you have. So,
Yes.
do you have any questions on either one?
No, sir.
Okay, then you are free to leave the meeting. My clerks will reach out to you either later today or sometime tomorrow with what's owed, how to pay, and again, ask them about the petition to seal this case. And I'm making a note right now that it's eligible once the warrants fee is paid, the petition is filed, and the filing fee for that is paid. It'll be automatic, okay?
Okay. Thank you so much.
All right, you are free to leave the meeting. All right. On the record regarding Arlen Bishop. Mr. Zarlingo, if you and Mr. Bishop would actually have Mr. Bishop at Station 1, if you would go to Station 2. Okay, give me a second here. This is case number 300681. The city attorney is indicating he's offering you, Mr. Bishop, a 6-month deferred prosecution, the conditions of which are that you are to comply with the terms and conditions of your Adams County probation. You're not to harass, annoy, alarm, molest, or contact Joy Bishop, and you're to commit no new law violations for a period of 6 months from today's date in Commerce City, other than routine traffic violations. Mr. Zarlingo, is that a correct statement of the proposed disposition? All right, and have you consulted with him regarding his waiver of his right for a speedy trial to take advantage of this? Okay, and I might have asked this question before. Good afternoon, Mr. Bishop. All right, you've heard me describe for your attorney what the city attorney is offering you. Do we have the case number from Adams County? I'll look it up later. Actually, I'm going to be more thorough than that. It'll only take me a minute. Oh, there it is. It's a county court case or district court? Okay. How long have you been on probation? When did they revoke and reinstate? All right, that's why. It's already fallen off. Okay, so let me think. What's the other way to look at it? No, I can't get to it from here. Yeah, all right, well, we'll just generically write down Adams County probation. All right, Mr. Bishop, your attorney indicates he explained to you your right to a speedy trial. Do you understand what that right is? And do you understand that you're being asked to waive your right to a speedy trial in order to accept the proposed disposition that's being offered to you? Are you willing to do that? That means that if this case, if you don't comply, your right to a speedy trial begins to run from the date that we reset this case for a disposition or a trial date. You have the right to a speedy trial in municipal court that's 91 days long. Because we're going for 6 months, we're beyond the 91 days. Has anyone forced you or coerced you to get you to waive your right to a speedy trial in this case? Has anyone made any promise to you that I'm not aware of or that you guys have discussed outside of my presence in order to get you to waive your right to a speedy trial? Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today? All right, I'm going to find you've made a knowing, intelligent, and voluntary waiver of your right to a speedy trial in this case. All right, so 6 months. All right, when you go to the windows in the lobby to see my clerk, they're going to give you a notice. The notice is going to tell you when the 6 months is up. Assuming that there's not a motion to revoke the deferred prosecution, after the expiration of that 6 months, you can contact the court. We'll give you a copy of the order of dismissal of the case, and then at that time, if you wish to seek filing a petition to seal the record, you can. You obviously can't do that until after the 6 month period is up. So, you know, stay away from Joy Bishop. My recollection is she's your mother, is that right? Okay. Don't harass, annoy, alarm, molest her, or any way retaliate against her. Don't pick up any new cases. If you pick up a new case, you're going to violate your Adams County probation, and then you'll be brought back here to deal with this case all over again. Exactly. That's exactly the way to look at it. All right. Do you have any other questions? No. Mr. Zarlengo, is there anything else I need to address for Mr. Bishop? Okay, if you'll go to the windows in the lobby, see my clerks. It's going to take a few minutes. They'll give you that notice, and then you are free to leave. All right. Mr. Zarlengo, are you here on Anthony Fontanelli? I am. Have you had any communication from Mr. Fontanelli? Okay, I don't see Mr. Fontanelli on our Zoom list. I know I keep asking this over and over, but now I should have it memorized. Your registration number? Okay. I'm making a note that you appeared. Defendant has failed to appear. Warrant will issue for his arrest. Bond will be set in the amount of a $200 personal recognizance bond. Evidently, the Adams County Jail is still not taking municipal holds other than crimes of violence or petty offenses or misdemeanors unless they involve crimes of violence. So everybody keeps getting a PR bond. I have a feeling that's going to change in the immediate future. Okay, are you here on Serene Donlin? All right. And you've already been on this one. Last time she was here was February 17th. And have you had any communication with her? She couldn't even join us by a Zoom or phone call or anything? All right. She's already on bond with a prior failure to appear. You can go ahead and make the request, but I'm going to deny it. Yeah, we only have courts on Wednesdays and Thursdays, Mr. Zarlingo. It's just Wednesdays and Thursdays. Those are the only dates we do. Again, if she hadn't had the prior failure to appear, and if this case wasn't from August of 2020 with multiple charges, I might consider it. But no, I mean, if you can get her to Zoom in on Wednesday or Thursday with her, I would consider vacating the warrant at that time, but I'm going to order it issued today. Set her bond in the amount of $400 PR. Again, it's a property crime, so I can't order taken into custody. And she's got false reporting, trespass, and theft on this case. None of those, I mean, it's a significant theft, but it's still not enough for the jail to take her. So on case number 298144, warrant will issue for her arrest. Bond is set in the amount of $400 personal recognizance. Let me call her other case. Case number 299638. This is a trespass case, also from August of 2020. And again, she's on bond with a prior failure to appear. I'll note, counsel, Mr. Zarlingo is present. The defendant has failed to appear. Warrant will issue for her arrest. Bond is also set in the amount of $400 PR bond. If you do have communication with her, again, if she adds on next Wednesday or Thursday, I'll vacate the warrants at that time, but I'm going to order them in effect today. Yep. Are these the only cases you were on, Mr. Zarlingo? Right. Okay, thank you very much, Mr. Zarlingo. You have a good afternoon. Okay, Lori Freeze, if you would unmute your device. Good afternoon.
Hello.
I'm going to need to have Mr. Gollin come in because he has you pleading guilty to one charge and dismissing another charge, but he has other notes on here. Trina, can you check and see if he's in there? Can you check and call the front or Jackie's or someplace? I need him to clarify this. I can go ahead and get started.
Okay.
All right. He says that if you plead guilty to the charge of the failure of the duty to report, Mr. Gollin, I need you first. In case number 285228, on January 8th of 2021 at 10:16 in the evening, in the area of 6171 Olive Street here in Commerce City, the city attorney will dismiss, excuse me, you need to write this on here. Yeah, you just wrote 12 months, right. Good, thank you. All right. All right, that's fine. Okay, now it's correct. If you plead guilty to the charge of failure of the duty to the report on January 8th of 2021, the city attorney will dismiss the serving an intoxicated person charge and is offering you what's called a deferred judgment and sentence for a period of 1 year. What that means is, even though you're pleading guilty to this charge today, I'm not going to enter it as a conviction against you. I'm going to hold it in suspense, have you do the conditions that he spoke to you about during the 1 year, and if you pick up no new law violations at the end of 1 year without the need for you to appear, if the conditions are satisfied, your guilty plea will automatically be withdrawn and the case against you dismissed. Do you understand what's being offered to you?
Yes, I do.
Okay. Is this how you wish to resolve your case today?
Yes.
Okay. I don't know if you looked at this the last time. Oh, this is your first appearance. Did you watch the Advisement of Rights video?
I did.
Okay, good. So give me just a second while I go over some of these rights with you. Do you understand that if I accept your guilty plea to this one charge, you're waiving your right to be represented by an attorney in this case?
Yes.
You're also waiving your right to be presumed innocent of the original charges, both of them, unless and until the city attorney is able to establish your guilt beyond a reasonable doubt at trial, because by pleading guilty to this reduced charge, you're waiving your, not reduced charge, this one charge, you're waiving your right to be you're waiving your right to have a trial as to both charges. Do you understand that that's what you're giving up?
Yes.
Okay. You're giving up your rights to confront and cross-examine any witnesses that the city attorney would call in support of these original charges against you. You're giving up your right to present evidence on your own behalf, including calling witnesses on your own behalf, and if your witnesses would not appear in court voluntarily, to have the court issue subpoenas for you free of charge, which could then be used by you to have your witnesses ordered to appear on the date of your trial. You're giving up your rights during the course of the trial to testify or to remain silent, and if it was your choice to remain silent, the fact that you did so could not and would not be used against you to establish your guilt. If at the end of the trial you were found guilty of either one of the original charges, you would have the right to appeal that conviction to a higher court. Do you understand that if I accept your guilty plea to this one charge, you're giving up all of those trial and appeal-related rights?
Yes.
Has anyone forced you or coerced you to get you to plead guilty to this charge against your will?
No.
Has anyone made any promise to you to get you to enter this guilty plea?
No.
Are you currently under the influence of any drugs, alcohol, or medications that affect your ability to understand what you're doing in court today?
No.
Then to the charge of failure to the duty to report On January 8th of 2021, here in Commerce City, how do you plead, guilty or not guilty?
Guilty.
I'll accept your guilty plea. I'll find it's knowing, intelligently, and voluntarily made with a full understanding of the rights being waived as well as the possible consequences. All right, the only conditions that he's asking for is that you complete 16 hours of useful public service and commit no new law violations other than routine traffic violations for the period of 1 year. There are no fines at this point because you're not being sentenced. There's $34 of court costs that I have to assess against you. When you leave the meeting, my clerks are going to give you a copy of the agreement for deferred judgment and sentence. They'll give you the community service form. You can do community service anywhere. It does not have to be done in Commerce City. The only requirement I make is that the place that you pick to do the community service must be a legitimate nonprofit agency, okay? I won't accept it if you simply do free works for friends, neighbors, relatives, or for a for-profit business. Make sure the place you pick is a legitimate nonprofit. You'll have a deadline of about 6 weeks within which to get it done. Turn it in by the deadline, and that part's done. And then the rest of it's easy. Just stay out of trouble for the balance of the year. At the end of the year, guilty plea will be withdrawn, case will be dismissed. Do you have any questions?
I do not. Thank you.
Okay, my clerks will reach out with you with the email with that information as well as how to pay the $34, and that'll conclude matters. You are free to leave the meeting. Thank you. All right, Yvonne Kleckman, if you would, well, she's not there. Maybe when she left the breakout room, she left the meeting. Warrant. For that charge, if she fails to appear at the warrant. She was there earlier. I remember seeing the name. If you get a second, take a look at the afternoon of April 1st and see if we've got room to put her there. Clickman.
hung up. I resent her the invite and I called her.
she's the one that has the animal class on the 27th. April 1st for pretrial? Is it, there should be room.
There's only 3 spots available.
Yeah, well, hers is gonna take no time at all.